want to argue it around taking FCT as one of the states. That is, we are now saying that 37 states. Now, when we say to thought of 37 states, it's not going to give us an even number. It's going to give us a fraction. So how do we consider this? Is it that the person is going to win 24 states and a half? Or I don't really get it when he's talking about 25% in 37 states now. You know, considering it as two thoughts, because it's going to give us like 24.666 thereabout. So please, can the lawyers help us when we are? Well, let's go into the mind of the people that have drafted this law and then try to help individuals here. Is didn't us can this be confusing the more when we say that to thought is actually inclusive of the FCT and is going to give us a fraction of the number of states? So how are we going to actually justify or get to have an even number from these 37 states, including FCT? Thank you. This is my question.
I get it. Let me quickly come in here. That's the same thing I've said over and over. I did the same thing you did because I'm a numbers person and I got the same thing. So at what point how do we interpret this thing to a point where we all understand it clearly? I should think they made this law, they passed this thing because they understood it. So why are they twisting it? Because 2/3 of 36 is 24 and Abuja. That's it. It's as simple as ABC. So when I say I get confused about this and the more I try to get it, the more confused I get. So you see, Maxwell is saying the law is ambiguous. We have to wait. Vice Julius said, well, let them interpret it. But I think as a layman, as a regular person, you should be able to understand it. It is more confusing than, I don't know. It is so crazy. You have to win Abuja, bottom line. You have to get 25% for you to be declared the president. 2/3 and Abuja. So why is this all and now an issue? Bryce Juliet, Bryce Dodger, UC Maxwell, please help us here.
You have a point. You have a point there. And for me, if it was actually okay, my own recommendation is that since the constitution did not say there will be a roundup of the uneven equation, to even if you're adding to third of 37, there's no even provision for a roundup. There's also no provision for the estimation should be that 25 states, if possibly, but FCT should just be taken into consideration. There was no provision for that word because in terms of interpretation, you should not leave it in an ambiguous. You should not leave the laws in an ambiguous manner. It should actually be something that will be well understood. And now there was no provision that FCT should just be taken into consideration as a state for the purpose of election. But for any right-thinking member would actually insinuate that for the extra addition of and FCT, meaning that while also getting your 25% from the 24 states, please be very rest assured to also get your 25% from the FCT. Since it's impossible to round off the 24 point something, or they should have made it that the 25 states should not be any other state, but consideration of FCT should be looked at as a state. So that provision is not actually in the law. And I'm sure that with this, if that's what we said, we'll leave it open to the court to decide. We all have our opinions, we have our recommendations, and my own recommendation is that for the drafters to do so, they should have had the understanding that 25% includes having it in FCT. So we hope that the court lays it to rest, and therefore there will now be an alteration, even if not an alteration, but people now know that this is what the law has been tested, and this is where the law stands on 25%.
Barrister Julius, you've now brought another one. 25% of 36, 25% of 36 states, including 25% in Abuja. Now we are battling with or and. Barrister Julius now said it should be including, which is true. It should have been interpreted in a way that a layman would understand. Man, we can't wait. Let me not derail you guys, but 24.6%. It don't make no sense. I'm sure they did this math as well, and they know it doesn't. That's why they said 25% of 36 states and Abuja. 25% of two-thirds and Abuja. But let's keep it going. Ladies, I mean, the more I try to think of it, the more confused I get. Angie and William, please, you're taking it.
All right. Okay, let's keep.
Thank you.
Okay. Angie, go ahead.
Please, if you like to speak, can you read it? Okay. Barrister Doja will go first. Sorry. Barrister Doja, please go ahead.
Okay, so I'd like to, contribute to the Abuja issue. I'm very sure that all of us on this space are well versed and aware of the two schools of thoughts with respect to the Abuja issue. But the thing about law is that I think for me as a person, I try to think as impassionately as I can, and it's not about whose interests. Obviously, it's in. I would say it's convenient. I mean, now that it's in our interest to say it has to be 25% of Abuja. I would like to add this because now that this is going on, in my presentation on Atiku's petition, I forgot to include it. When Atiku was presenting his petition, he actually added as evidence a document. That document is supposedly a document that was used when the 1999 Constitution was being drafted, and it's supposed to show the intent of the draftsmen with the Abuja 25%. Now, I don't know how he came into possession of such a document, but he, pleaded the document as one of, evidence that would show that the 25%, the and 25% intended to mean that it must be 25% of Abuja, not just 25% of any other states. In my own opinion, my humble opinion, I believe that it's my own opinion is that it's tricky in the sense that there are certain questions that will come to the fore, and then the Supreme Court is at liberty to interpret it in a way if they feel like the interpretation would hurt injustice or something along that line, that is not going to be very fair. They are at liberty to interpret it whichever way they choose to. But I think if we're going to be very passionate and we are going to be very, neutral about this, I do not think it's the intention of the Constitution to create special voters in Abuja. Because when we think about it, if you have to imagine the scenario that if an election occurs and somebody wins all 36 states and fails to get 25% in Abuja, does that mean they are going to conduct the election 100 times? But you see, at the same time also, even though the Constitution did not mean to do that, if it is clearly stated, and that has happened, because they probably never imagined a scenario like this would occur, but the scenario has occurred, and we see that, okay, this thing has a potential of being a dangerous precedent. With respect to now, if the law is what the law is, the law doesn't know morality. Interpret it. The obvious push should be interpret the law the way it is. Then let us go and amend the Constitution and expunge it from the law. I don't know if you all remember. This was very recently when they passed the Electoral Act as amended 2022, and there was a section there that states that if you are, the section when you interpret it states that if you're a public, if you're a public officer, you are not allowed to participate in the primary election, and you must resign. A certain number of months before the primary election of your party. That section was deemed as being unfair, but everybody obeyed it. And it wasn't until it was taken to court, and then the courts, ruled, and the court ruling pretty much expunged it, that it was then seen as okay. It's okay. But in as much as the court hadn't said otherwise on it, it was very valid. And assuming the court had ruled to recognize it, would have had no choice but to amend the Electoral Act to expunge it. So it's the same thing here. I like to think that when they're deciding on that Abuja 25% issue, according to the former Attorney General of the Federation, he says the issue has been discussed before and it was decided that Abuja is and is conjunctive, is not, what do they call it, is not, the and is conjunctive, which means Abuja. You must have 25% in Abuja. But like I said, the Supreme Court has the liberty to overrule itself, and that's a fact. The Supreme Court can rule in a certain manner and then decide that we no longer want to be ruled in this manner again. So it's very tricky. Yeah, there's a lot of tensions and emotions and all that. I mean, with respect to 25%, because it's looking like the 25% can be a deal breaker. But I think what we should, no matter which way it turns out, if it turns out that, no matter which way it turns out, we almost agree that, see, that 25%, irrespective of the judgment granted by the Supreme Court, is actually, would I say, an impractical and unfair provision, in the sense that what it aims to do is to create a special class of voters, which is not good for the country. But it is the law, and if it's implemented, even if it's the court rules and says that is what the law is, we must attempt to change. We should attempt to change it, because today it might be in our favor. Tomorrow, what if it's not? And if it is what the law says, yes, we follow the law and then we go ahead to amend it. And if they say otherwise, we respect it as well. And this, I'm saying in a very unbiased manner, because you see, the thing about the law is that today it can be for you, tomorrow it can be against you. So it's always good to always stand on the side of equity and fair play, notwithstanding whose ox is God. Thank you.
Thank you, Barrister Dodger. Appreciate you. Thanks for that explanation, man. That is pretty well understood. Yeah, ladies, go ahead.
Thank you. Okay, I'm going, please, if you have something to say, kindly raise up your hand, and I'm going to pass the mic to Laddie. Laddie, please unmute your mic and speak. Sorry, please, who was the last person that just spoke, so I can drop you and bring another person? Okay, it was Dodger. Eddie, were you the last person?
No, the last person dropped. The last person dropped already, so
okay.
Laddie,
please go ahead.
Thank you very much. Good evening, Mag. Good evening, Wemi. Kosi has dropped. Good evening, everybody. Sorry, I haven't been on the space long, but I do have a question. So if you've treated it, I do apologize. Okay, the way I understand it on the Abuja issue is that, is it true that as president, the president is governor of FCT, because essentially there is no governor there, there is an appointed minister. And so therefore, for him to be governor of Abuja, he would need to do what every other governor does, which is win 25% of 2/3 of his state. And so that essentially means that for you to be president, for you to win, you'd have to win Abuja on its own. Thank you. That's my question.
That's what we've been discussing, but I'll let Dodger go again, or Pastor Juliet. Any of you can take it.
Let me just say something about this. Very simply, because I know that this would be, even people are also in my DM saying the same thing. So let me say this. Anytime that a law is not so very clear, anytime there are issues with a particular provision of the law, the astuteness of the lawyer comes into play. It's very, very relevant for me to say this. We saw a lot of issues when Audu Abubakar of Kogi State died, and there were a lot of lacunas in the. That was when we realized that. So this our constitution like this can be so, cannot provide any answer whatsoever to the situation on the ground. Neither could the Electoral Act provide anything until after that situation and the court judgment, there was an amendment before questions could be answered. What the last lady who spoke came here to say are also arguments by a school of thought that are saying, and if you listen to the interview by Kenneth Okonkwo, he said that expressly, that how if you are to be a president as the executive arm of governance, the federal executive arm, the seat of power is Abuja. So Abuja is more like the state to the president. And I'm not just saying this because this is my interpretation. It has been interpreted by courts that when you want to look at FCT, the same way you regard the governors of states, you should regard the president as the governor of FCT. Simple, the court has said that. So they are now saying, if you are to be president, why shouldn't you win your state, your constituency properly and get the 25% vote? So this is another argument. And all we have been saying since before you came and even after you came is that the courts can be swayed by whoever's argument is cogent enough, more persuasive to the courts, because as it is, the court would rely on past judgments and also the logical interpretations of these lawyers. So we are waiting to see. Every argument by each school of thought is legitimate. Somebody will say it is unfair to all citizens of the rest of the 36 states if you say that for a person to be president, he must win Abuja. Another person will say, okay, he will be president and his seat of power is Abuja. Is he not supposed to be accepted by a 25% majority in the seat of power that is Abuja? So these are just different arguments to the case. And your guess is as good as mine. You are supporting a candidate, you would always tilt yourself, like Doja said, to the argument that furthers your cause. So we are going to wait and see what the court is going to hold. And, hold your argument for now. We can canvass any arguments we want, but we'll wait to see what the judge will say.
You see, this waiting till Jesus Christ, this waiting is not an easy waiting, but we have to wait. Let's keep